you so much for remaining with us. You're watching The Point, and this is Smart24 TV. Remember to hit us up on social media. We are on Twitter at Smart24 TV. My personal handle is Anthony SSEBBAALE, and you can also get on our YouTube right now. We are live there. In the comment section, we'll be able to get feedback. We'll be very, very glad if we got that from you. We are talking about domestic work. We've already looked at what the Constitution has to say under the Article 40. We've also talked about the rights that actually domestic workers hold in the community. They are supposed to be paid. They have a right not to be sexually harassed. They have a right to take leave. And some of you didn't actually know this, but they do have all the rights that any other worker working for any other organization does have. However, this year, 2022, saw the first hearing of the bill, the amendment bill of the Employment Act 2022. Now, this act, of course, has certain provisions where they have casual workers catered for, and of course, people that are formally employed. But not much is being said about the domestic workers. And so it was tabled actually to bring to the notice of the legislators the casual or domestic worker and some of the things that haven't been actually taken care of. One of those being the NSSF, the Social Security Fund, being, covering the domestic worker as well, the pregnant mothers who are working with the domestic, working organizations are not also being catered for when it comes to leave. So we want to talk about some of these amendments. And Ms. Lydia, on this one, I want, first of all, to ask you, what was the object of this amendment? Because I've seen you personally speak strongly, first of all, on the privacy in the homes. You were saying that these homes are so private to the extent that they are not called workplaces. So what does the amendment bring on board? Does it change the home setting into a workplace setting? What new thing does it bring on board?
Thank you so much. I've read into the amendment because it's a private member's bill, but also I know that the Ministry of Gender, Labour and Social Development, they are also processing an amendment bill for the same Employment Act. The cabinet passed the policy principles for the amendment. So it is now going to have like two bills in Parliament. But I've read into the amendment for the private member, that is Ms. Kunihiro, I think.
Yes,
is the one who brought it. The object of the bill is to operationalize Article 40 to all categories of workers. And there she goes on to state that the bill specifically looks into the regulation of the recognition and regulation of domestic work and domestic workers as workers. It looks into the casual workers. It looks into breastfeeding facilities for breastfeeding female employees, looking into breastfeeding, sexual harassment, is expanding the scope of sexual harassment, but also seeks to introduce definitions like the workplace. So that's where you maybe outside from. So that bill, when I read, it does not have a lot of provisions around domestic workers, by the way. It defines domestic work, domestic workers. And the bill has adopted the definitions that are in the ILO Convention number 189. Okay, so who is the domestic work and what is domestic work? Domestic work is defined as work done in or around the household. Then a domestic worker is a person who does the work in and around the household for remuneration, for pay. In other words, my children will not be called domestic workers just because they are doing work in and around the household. No, they have added for pay. The person has been employed for pay. They're doing this work for pay. So then the bill went on under, I think, amendment 30, the amending section 38 and 34. 34 is on special categories of workers. And that bill is suggesting that domestic workers should be recognized as one of the special categories of workers that require the minister to come up with regulations for these kind of workers. Because right now we have casual workers, we have apprentices, we have persons with disability as special. Now they have added in domestic work, that the minister should treat them as special categories of workers that need special protection under the law, and the minister should come up with regulations that effect to be able to regulation under section 97 to be able to expound on the employment and the rights of these kind of workers like the domestic workers. So that is in as far as domestic workers are concerned in this particular amendment. But the beauty about that amendment is that at least it recognizes domestic workers.
Yes.
The mere fact that it's even defining them and putting them as special categories of workers that need special protection. And you know why? Because under the current employment, the National Employment Policy of 2011, that National Employment Policy, domestic workers are one of the vulnerable categories of workers that require special protection. So, if the bill is now proposing that the law, now the Parent Act, should be able to recognize them as special categories of workers, it is just actually a fulfillment of a policy that already exists. Because the policy was made in 2011, yet the law was enacted in 2006. So there is a lack of a meeting of mind of the two, the policy and the Act of Parliament. Yet the act should be fulfilling what is in the policy. So I think for me that is a very good step forward. But also it's a good step forward for the country at large, because recognizing domestic work in that manner, it will be a step forward. Maybe to address doctors' concern and where he was saying the cultural, the tradition and the cultural stereotypes, it will address them, because then, them being in the law, that even people will get to know that, even domestic workers are actually also under the law, and therefore they are actually workers, because they are looked at that. The other section 38, that they are amending is section 38.3, 3A, I think. They are amending it, and why they are amending it? Because that section 38 is on requirement for recruitment permit. So it covers the recruitment permit for workers going to work abroad, but it has an exception that you don't require a recruitment permit if you are recruiting domestic workers or non-manual laborers. So by virtue of that existence of such a provision in the current act that we have, it means that people who are doing this work, whether formally or illegally, whether informally or those who have even managed to register, they are not supposed anyway. They don't require a permit.
Yeah.
And the lack of permits in this, the lack of regulating the recruitment process of these categories of workers, the domestic workers, which, by the way, the policy is saying that they are vulnerable and therefore they require special protection under the law. The international standard, which is the ILO Convention number 189, is saying these categories of workers are vulnerable worldwide. They require special protection, and that's why. How many other laws do you know? How many other workers has the international committee come out to form a convention? No. It is only such workers. I think we have plantation workers and now domestic workers. So, meaning that there are special categories of workers that require special protection in any legal, regime. So, so the fact that the law is saying that you don't require a permit to recruit and place domestic workers, it is no wonder that we have seen that there is even growing criminality within the domestic work sector. That you can get a domestic worker from an informal recruiter anyway, they are not even required to have a license anyway. Then they connive to steal from you. Why? Because the law is saying you don't need a permit to recruit domestic workers. And yet these are people who are being recruited and placed on a daily basis in people's homes.
In the current laws,
yes,
we don't have any provision for licensing for recruitment permits.
Yes, for domestic workers.
For domestic
internally.
Workers. Wow.
Yes, internally. If you're recruiting for internal, and you're recruiting domestic workers, you don't need a license as per the section 38(3)(a). So you don't need a license. And that's what the bill is also saying. No, we need to recruit every category of workers. Whichever, whether they are market vendors, domestic, we should be able to regulate them. We need to be able to regulate them. So you cannot say you're not going to regulate their recruitment, because these are people who are going into the private setting of our homestead and their workers. So that's what I'm saying. That's why criminality has, that where domestic workers even connive with recruiters, these informal recruiters, even informal one, perhaps they connive and they steal from you, the employer. Or they connive like this. They come today, you pay the 100,000 for recruitment fee. Tomorrow she tells you, I've lost that person, I'm going. It's a business. Why? Because no one is mining the sector. No one there is no regulation for the sector. Anyone can enter, anyone can recruit. And that's why it's very important that we start institutionalizing domestic work. These people need to be trained even. Like we were discussing over a break, that, we've even seen that domestic workers, people who come to work as domestic workers, they also come to work. They join the sector and they don't take themselves to be workers themselves. And therefore, the acts they do, they don't know that some of the acts they do, they can be taken criminally. They don't even know how to behave and conduct themselves towards the other person, because they're not being trained, because no one is first training them. And yet when they come to our homes, we want them to act professionally. And yet they're not being prepared. The mind is telling them, I am only here because I failed in life. They're not taking the work they're doing as work. So why? Because there is no prior training. Anyone can recruit, anyone can join, such a thing. So that lack of that, we saw sometimes we see domestic workers, doing criminal acts. We saw the case of Mole, and the Kamanzis, where the child was being, strangled in that home. But why? Because sometimes even the employers are treating these people badly, and then also the domestic workers also made out to these young ones, because they are defenseless. But why? Because there is no proper regulation of the recruitment and employment standard for this person, that anyone the potential person to become a domestic worker, they join knowing that I am also a worker, I'm an employee, I'm going to work. Let me draw a comparison. You see people who are going to work outside in Saudi Arabia as domestic workers. They are going not so much because of the money, but they feel like there is even a contract. For the first time, I get a contract to be signed as a person. And here there are so many people who are working even in formal setting that they have no contract. They are being employed. And there's a domestic worker there with a contract of employment. So
I think I've seen that 4 months, I think there is going to be contraction at least for 4 months for every domestic worker, if this comes to pass.
Yes. There will be in terms of a contract, you have to have a contract. So the bill also looks into the casual employment, trying to convert casual employment into term contract, like a contract employment. And it's saying, and this, by the way, this one is already there, but it's in the regulation of 2011. But what the Member of Parliament is trying to do is to bring the principle, because the Act right now does not have principal provisions around casual employment. So it's picking that provision from the regulation and putting it in the main Act of Parliament, and saying that for a person who has worked with you continuously for more than 3 months, on the 4th month, they will become what? They will become permanent contract employees. Whether you have given them a contract written or you have not given, they will automatically turn to be. But of course, we know that there are people also who are very brilliant. They will start employing after 3 months, they terminate. But they are put a clause there, which is very interesting, that if you rehire this person within 21 days, we count it as a continuous period. So I may hire you, or you may hire me for 3 months, and say, because you are trying to avoid this for me to be permanent, you may let me off. But you will not let me off for the entire month if you really need my service. So they're saying, if you employ this person within a period of 21 days after the first contract, then we shall count it as continuous employment. So there are those particular safeguards. I also want to talk about the whole issue of the home. That once, people have been arguing about this, that, once we over-regulate the domestic work, these people work in our homesteads, and, privacy. First of all, I want to, Anthony, is that right now, the home is not only employing a domestic work. It's not. People have put garages that become, workshops, and people are working in those garages. You're employing people in your home. By the fact that you have employed people in your home,
you've opened the doors.
Stop crying foul to privacy.
Yeah.
Stop waving the card of privacy. No, you have employed people, which people the government has a responsibility to protect them as workers in your home. So domestic workers are not the only people right now working in our home. There are other workers who are working there. People have bakeries. People have catering services. They're doing all sorts of things. People are making mats in homes, and they're employing people. So why shouldn't we have that home as a workplace?
But it's still a home. I still have my children. I still have my wife. So I need a little bit of privacy, sometimes.
Anthony, let us agree. There are different things why people use their homes as the factories. Yeah. People want to evade paying ground rent, ground taxes, all those things. Yeah. As you're avoiding that, this government has a responsibility to protect the people who are working in your home. For example, if they got burnt in your home, who is responsible? Should we say because it's private we should not look into it? The government has a responsibility to look into it. So that is why we are saying the home. And by the way, Anthony, let me tell us, the home is already a workplace. Under the Workers' Compensation Act, that law of 2000 defines a workplace, and it is so elaborated that it covers everything where work takes place. Everything. It even goes as far as saying open space, ship, anywhere, and it ends by any other place where there is work taking place, whether it is on the road, people who are constructing. When they are on that constructing of that road, that is a workplace. Yeah. So you cannot say that now for you because it's your home. Yes, I know that the argument comes from Article 23 of the Constitution, which article carves out the home as one of those private entities. Yes, and we agree. Even for one to search a home, you need a search warrant. So it is okay if let's say the labor officer or the LC1 chairperson is going to access your home where you're employing domestic worker or other workers, they can be escorted by a police officer, just like in a search warrant where they're escorted by a police officer. That's Article 27 of the Constitution. Article 23.
Okay, that's about the home, the private.
Yes, the home. So if we feel like the home is so private, when you're employing and should there be a dispute that it requires the labor officer to come in this space of yours, then they can be escorted by a police officer, as it is done in other instances when they are searching a home, so that you are protected. Otherwise, we can no longer continue crying, because we have these categories of workers whose workplace is a home. They work in this home. So we can't wave the card of privacy. No, once we are employing people in that particular home.
If you win on privacy,
yes,
then the issue of the Social Security Fund.
Good.
There is and before we get into the Social Security Fund, we have not dealt with the minimum wage. Already on average, I am sure on average, the most highly paid maids earn about 300 to 400,000.
Yes,
that is on average in an average home, and most that is for a few. But most even earn less than 200,000, which makes them even more vulnerable. Now, you want to bring on board NSSF, and NSSF also comes with URA, right? And so many other things that are going to come in here. What's going to happen to the wage of this domestic worker who is already earning peanuts? Shouldn't there be something to be done, especially with the minimum wage first? And then we address the issue of the payment and all these other amendments in there.
Actually, I don't know, when you're speaking, asking this question, I remembered when we were appearing before the parliamentary committee, some section of the members of the parliamentary committee on gender, they raised an issue that if we put the home as the workplace, it will attract ground rent.
Exactly.
But we said no. Yes. The bill can make an exception, and so then the income tax will have to be referenced and say, however, for avoidance of doubt, the section on grounded shall not apply to a home where a domestic worker is what? Being employed. But remember, and we told them the challenge that is going to be is that in other people's homes, there are factories. So they will also use it as an excuse that no, I'm using this is a domestic worker. But we gave us an option. But going back to the question of NSSF and URA, pay as you earn. Yes. I think payee for it is a bit okay because it has a threshold of 230. Below 230, you don't pay payee. And we know that on average, people are earning below 230 on average. So that may not be. But those who are earning above that money, then ideally the employer is supposed, but even as individuals, we're supposed to have TIN numbers. Then you're able to pay payee for that particular person. I mean, they're not the only people who are paying a tax. They are domestic workers, but I mean, government has to give them social services, so they should pay taxes. If you are earning within the range of the tax threshold, you should be able to earn. And by how much? If let's say you are earning, and sometimes people misguide people. If let's say a person is earning 350, so we get it's more than 230. So we get 350 minus 230. The 10% is only put on the difference between the two. It's not on the entire amount. So it's not a lot of tax. And I always say people pay taxes. It's not a lot of taxes. I'm also a tax expert, so in that. So I always tell people that pay a tax. It's not a lot of money. When it comes to NSSF, that's where the challenge is, because for NSSF, it is not as is with payee.
Tax, yes.
Payee. I may not be paying payee, but when I have to pay NSSF, even if I'm earning 90,000, my employer right now, as long as you're employing a person, 15%, you should be able to deduct 5% and add what? 10% and remit my NSSF. Meaning, individually, we are supposed to go and register as employers. If you're employing any person, you're employing domestic worker or other people whom you have, because people are employing other people. So you have to go and register as an employer, and also these people, your workers, your workers also have to go and get the NSSF number. And let me tell you, actually, this is little money. Yes, you're earning little money now, but remember, this person, the domestic worker, they will also grow old, just like me and you.
Right. I've actually remembered the story. There's a maid who grew up with a certain family, I know. I think she's now something like 60, and she's still stuck with the family. Why? There's nothing to move on to.
There's nothing to move on to. And even in their old age, is 60, but to reach a point when she has to go back to her home. Wait, what is she going to use? Who will be looking after? So this social protection or social security is for you, the worker. It's not for the employer. So even generally as workers, I encourage you, don't connive, don't allow to be hoodwinked by employers who tell you, you see, I can give you your money instead of putting it in NSSF. They even tell you how NSSF money is being eaten. Is there any worker who has gone to NSSF to get their money and they have not got it? No. For us, we shouldn't mind so much about if it's being eaten. The moment I clock the age or I'm supposed to access it, I go there and access it. I should not be told that, something happened, money was eaten. No. No one has been given such an excuse. So we should not use. So even if it's a domestic worker and they are within that, I think, and by the way, in other countries, having a social security number is normal. It's like part of your identification. It should be part of our identification that you have your social security number, because when you go to hospital, they even use it. Are you insured? Because that's why we have been telling NSSF that your products, they need to enlarge so that I can use my NSSF card to treat myself if in case I get a illness that is beyond my pocket. You understand? So that's why it's important to have the social security number. It's not only used in the old age. There are times when we get shocks, life shocks, that really require us to use it. So even these workers, and the workers, this is your money at the end of the day. Moreover, the employer is managed to add on 10% of what you earn. So don't allow to be hoodwinked. Because they might tell you, let me give you all your money. Why are you saving? Those people, when will you get it? How sure you live for 60 years? my goodness, how sure is he or she that you're not with for 6 years? So it's your money. And it will be, in terms of enforcement, is the biggest challenge. How do we enforce individual employers? Because it's easier for companies, for registered entities.
They have products on the market. So
products on the market, they have TIN numbers, you can track somehow. But the problem is going to be in the individual. But generally, as a country, we are struggling with the limited coverage of social protection, even social security itself. Amongst the employed population, still a few, it's about only 14% of those employed are the ones remitting NSSF. So we need to continue, and for workers to know that this is your money. Don't look at only today, even tomorrow, you know. And people have stopped dying young, by the way. People really are living. We have learned to eat well, we have done what, and all those things. We are hitting the gym. So you cannot be saying that you're going to die. So, and nowadays, even they have given us another chance. They used to give us our life expectancy was at 45.
Yes.
Okay. So even at 45, now you can access part of your NSSF. So at least live at 45, you access part of your NSSF. You use it for something, but at least when you've saved. But I know that enforcement is the biggest challenge for the informal sector, where even domestic workers fall. How to register individual employers to be able to remit with NSSF.
Thank you so much, Ms. Lydia. We're going to take our last break, and we are coming back to wind up. And you've shared a lot on the amendments. Though you even mentioned about, for example, the severance allowance. We do also have the leave for surrogate mothers and other pregnant women, and some of the other things that are in the bill. We want to wind up with those, but also a call to the different domestic workers. What should they be aware of? Are there any, platforms where they can get help, including, of course, your NGO and the different other government players? What can they do in order to improve this space? We are still talking the domestic market and the domestic work market. We're talking about the employers, the employees. How can we have a harmonious working environment for both of them? My name is Anthony. We are taking a very short break. Stay with us. Don't go anywhere.